Gentleman from one.
Thank you, Mr. Speaker. Ladies and gentlemen, first to address the good gentleman from three's comment that for us that oppose this bill, that somehow we are going to cower. I think that everybody here knows the last thing I am is a coward. And I would challenge anybody to try to even address that to me. Mr. Speaker, I have spent a tremendous amount of time on trying to get my thoughts together. I've accessed my father, scholars, colleagues. This is a difficult thing for me because I believe that this is at the very root and foundation of our oath of office and what we believe in. Mr. Speaker and members, I live geographically further away from this building and the seat of government than anybody else that serves here. And I don't think it's only geographical anymore. I think it has to do more with relationships, and not one-on-one relationships with each other, but relationships in what we studied in our beginning civics, government civics classes. How can we have all been taught the same things and arrive at such different outcomes? It's mind-boggling to me, and I would like to attempt in what pathetic way that I can, Mr. Speaker, to address a few of those issues. Before I do that, I want to remind this body that we grew up pledging an allegiance to the flag, and we continue those things here today. And those words have meaning not only to our children, but they should have meaning to us. It talks about our indivisible nature. It talks about justice. It talks about liberty. But justice is something that is done through a realm of government that is not us. Justice is done through a realm of government that is the judiciary. We have a rule of law here, and I believe that that's a part of what House Bill 117 is violating. The furtherance of that pledge we do every morning is something we had to do constitutionally before we sat at our chairs. And constitutionally, we're required to swear an oath of office not only to the United States of America, but also to the state of Idaho, and to uphold that Constitution. It's a fundamental requirement, that oath is. And it's a step further than allegiance we make every day to that flag and to this republic. So in my efforts not to prolong this any further than I have to, I'm going to give my assessment of a short civics class in how this whole thing is developed in my mind. And so that I don't err too much, Mr. Speaker, I have put my notes down to print that I may be able to be more clear. In the beginning of our nation, we had the Articles of Confederation, and then we moved to a constitutional form of government. We had to form a constitutional convention. And there were great concerns under the Articles of Confederation, as James Madison declared, about the tendency of the states to encroach on federal authority, to violate treaties and to infringe on the rights of interests of others were those basic tendencies that he was speaking of. And the question arose how to prevent this mischief. A proposal was introduced by John Randolph of Virginia to empower Congress to negate state laws and that violated federal laws. That idea was embodied in the two plans presented to the convention: the Virginia plan, which favored the interests of the larger states, and the New Jersey plan, which favored the interests of smaller. It found sanction in the Supremacy Clause of Article 6 of the Constitution, which make federal laws in pursuance to the Constitution the supreme law of the land. Everybody there recognized that the federal laws not in pursuance of the Constitution would not be the supreme law of the land, as this bill is suggesting also. But the question remained, who decides what law is? In the Constitutional Convention and in various ratifying conventions, delegates after delegate stated that the federal courts would make that final decision. Even opponents of the proposed Constitution freely admitted that the federal courts would determine the limits of that congressional power. State courts might declare a federal law unconstitutional, but under the Supremacy Clause, state courts would be bound by federal court ruling. Why? Because the framers sought uniformity when it came to the implementation of federal law. And the need for that Supreme Tribunal to ensure uniformity was mentioned in the Convention and also in Federalist Papers number 80. Alexander Hamilton stated, 13 independent courts of final jurisdiction over the same causes arising under the same laws is a hydra in government from which nothing but contradiction, confusion, and anarchy can proceed. The point was also made in the Virginia ratifying convention by Madison and Pendleton, and in North Carolina by Iredell and Davie and Pinckney, and by others up and down the eastern seaboard. The point about need for uniformity was repeatedly emphasized in the Supreme Court, as seen, for example, in Martin versus Hutter, was the supreme decision maker to determine what law was. It's been suggested in House Bill 17 that we have with us, in support of us, from what we proceeded with last year to venture into a lawsuit. We do have a favorable ruling. We've got a couple of them. We've got a couple on the other side. But this is round 2 of a 3-round fight. Everybody agreed that the Supreme Court would have the final say, not a federal judge somewhere to make that determination. The concerns about the confusion caused by the 13 separate interpretations of federal law pale in this era to have 50 hydras out there interpreting what federal law is on a day-to-day basis during our legislative sessions. In Federalist 39, Madison wrote that the Supreme Court is to ultimately decide all controversies relating to boundaries between states, national governments, and their differences. Proponents of this bill read the 10th Amendment differently than I do. They say it grants to the federal government only those powers that are expressly delegated. I don't find that to be true. It's not in the language. And I suggest you look at it. At the time of the framing, some wanted to embrace the qualifications in the grant of power to Congress, which had been the phrase used in the Articles of Confederation, but the Convention rejected all efforts to that measure. The framers recognized that such an approach would require an exceedingly long and complex legal code, the sort they did not want and refused to write. And those are all documented comments through that convention. Moreover, framers wanted to grant Congress some latitude in exercising its constitutional powers, and so they included the necessary and proper clause, granting Congress the authority to pass all laws necessary and proper to carry into the execution their foregoing powers. Mr. Speaker, if you bear with me, I would just take a little drink of water. So what are the pillars of House Bill 117? The claim is that the Constitution is a compact among the states. That's the claim. I don't believe that to be true. States were not parties to the Constitution. The people, as the preamble declares, ordain and establish this Constitution. The people proclaim and ordain. It does not say the states ordain. It does not say the states establish. As the court said in McCulloch versus Maryland, the preamble is proof that the people, not the states, wrote the entire Constitution. Further, proof is seen in the fact that state legislatures were not asked to ratify the Constitution. It was, in fact, the people. And they were elected specifically for that cause. We've heard some talk from the good gentleman from 7, Jefferson, the Kentucky Resolution, different things. What of Jefferson and the Kentucky Resolution? Well, it was pointed out that Washington was not a fan. Washington rejected the idea of nullification or interposition or to make null and void. Put any words you want in, they all have the same meanings. He called it preposterous and a road to anarchy. Only one other state agreed with Jefferson, and that was Virginia. All the rest shared the position of Washington, John Marshall, Patrick Henry, among many, many others, all of the others. Nullification, that opinion, nullification would lead to the dissolution of the Union. That 13-headed hydra making up decisions that were to be delegated to the federal government. And they were right. Calhoun picked up the idea to justify secession, and that doctrine plunged us into a national civil war. When in the midst of the 1830 tariff crisis, folks wondered where Madison stood on the issues whether South Carolina might nullify federal tariffs. He said the states had no authority. When critics pointed to the language in 1798 of that Virginia resolution, that it said that the states might interpose themselves to protect people from violation of those rights, he explained that that meant only that the states could draw on tools available to them to stop federal laws that they opposed, and those tools being elections and impeachment. And there's another tool available to us, and that's convention. Nullification is not one of those tools, in my mind. He fully rejected nullification, agreeing that it would cause the dissolution of this union also. Mr. Speaker, ladies and gentlemen, we had a couple full days of hearings, well, half days of each, I guess. And I appreciate the angst amongst the people about the frustration that we see in the federal government. I have publicly declared my opposition to the Affordable Health Care Act. I do not believe it good for the country. I do not believe it good for Idaho. I was recorded last year in a vote to just that effect. And I'd like to see it repealed and would hope that the Supreme Court would declare it to be unconstitutional. That is my fervent hope. Such a ruling would be a victory for Idaho and would vindicate our decision to challenge it in federal court. While I am strongly supportive of our state's efforts to defeat the act in federal court, I harbor grave concerns about House Bill 117 and its claim of state authority to declare an act null and void on the basis of state power to nullify or to interpose this legislation. I believe, Mr. Speaker, that Congress has exceeded the constitutional authority in passing the health care law, and I now believe that this body will be exceeding its constitutional authority if they pass House Bill 117. That old adage, two wrongs don't make a right. Folks, I believe that we are on the right track. I think that we are fighting a battle that needs to be fought. But I ask you not to enter into what I think could be unconstitutional. Mr. Speaker, states that have no constitutional authority to nullify laws, if that be the basis, I would advise all of us to think closely what that means, what we do here today. Article 6 of the Constitution, the Supremacy Clause, makes it patently clear that federal laws pursuant to the Constitution are the supreme law. While I believe that the federal law is unconstitutional, it is for that Supreme Court that our founding fathers, all but two, decided would be the final arbitrators of those issues. In this case, to say that the law is not of the states, it's of the people. The people made these decisions. No Supreme Court ruling has upheld the claim that states have the right to nullify federal laws. If that were the case, then our nation would be reduced to 50 separate entities. And I want to reiterate that the theory behind nullification has engulfed our nation many times in many struggles, the worst of least being our national war, the North versus the South. And Mr. Speaker and ladies and gentlemen, I've been called many things to this, and where I will not cower in what I have to do, the threat of being recalled myself, the threat of being called things that are unkind and quite undisciplined. I will not cower from those things. You can call me what you wish. What I will do is tell you what I believe and vote for what I believe, regardless of the political expediency that is out there. And it is out there, and we all know it. It looks like the right thing to do because, by gosh, we want to get reelected. The blood that's drenched the soils of this nation, they weren't worried about re-election. They were worried about liberty and justice under a rule of law that the Constitution laid down. Speaking as a member of that Republican Party, Mr. Speaker, I'm proud to celebrate Abraham Lincoln's birthday 3 days ago here in this body. He was the founder of my party. President Lincoln, as was suggested, was opposed to nullification and secession, believing that the states had no authority for that. Ironically, Mr. Speaker, we find in House Bill 117 a measure that would abandon some of those very ideals of the founder of my party and actually begin to endorse the values of Jefferson Davis. The co-sponsors of House Bill 117 said if, in the end, the U.S. Supreme Court declares the federal health care law is unconstitutional, then the state of Idaho will honor that ruling. I commend the members for saying such a thing. I respect that position and would agree that our state would be obligated to do just that. But, Mr. Speaker, if that is our position, then I believe it is our responsibility to honor all the uniform decisions rendered by the Supreme Court since the dawn of the Republic that have held the states have no authority to nullify, that to declare null and void any federal laws is unconstitutional. I believe that we should continue to pursue our litigation in federal court into the Supreme Court, but that we should abandon House Bill 117. My two favorite speeches, Mr. Speaker, are the Gettysburg Address and Martin Luther King Jr.'s I Have a Dream. For many of us that weren't students of government civics classes later in life, as I was in my studies in college, we've heard those words, nullification and interposition, before in our lives, and sometimes we forget where we hear those words. Those words were actually two-thirds down in the I Have a Dream speech by the late Dr. Martin Luther King Jr. Those are great words that he puts there. I would ask ourselves to remind and be mindful to reread not only the Gettysburg, but also the I Have a Dream speech. It talks about the soul of a nation. And for me, Mr. Speaker, I appreciate your indulgence in my longevity of this debate. I'm apologizing that I'm not a better advocate for this cause. There's so many better people, not only outside, but also in this body that could advocate this. Let's not allow political expediency for the concerns out there to be reelected or whatever those concerns are. Let's abide by the constitutions that we swore to uphold. And let's abandon this idea that 117 is going to somehow relieve us of our proper duties and roles in government. Thank you, Mr. Speaker.